Welcome, members and guests. Today is Tuesday, March the 1st, 2022. I hereby call the Civil Justice Subcommittee to order. Ms. TJ, take the roll.
Representatives Clemens, Curcio, Farmer, Garrett, Griffey, Ogles, Parkinson, Ramsey, and Chairman Russell. Chairman, you have a quorum.
Thank you. And members, are there any personal orders or announcements this morning? Okay, seeing none, I would like to welcome the Loudoun County leadership group. If you'll just sort of raise your hand and we'll give you a big state capitol welcome. All right, we're going to take care of three items here first. Item number 4, House Bill 2501, Road 1 Week. Item number 8, House Bill 2724, Road 1 Week. And item number 9, House Bill 2435, Road 1 Week. First up is item 1, Representative Reagan, House Bill 2117. Do I have a motion? We got a motion and a second. Chairman Reagan, you are recognized on House Bill 2117.
Thank you, Mr. Chairman and committee. Let me start off with saying Happy Mardi Gras. I got that in first, so. The bill I bring before you today is a very important one in my estimation. House Bill 2117 basically reinforces the right of voluntary consent and bodily integrity. These have always been recognized under common law, not just in this country, but in British common law before we were the United States of America. It is, in fact, one of the most sacred underpinnings of the liberties of our republic. This core principle is cited in the First Amendment to the United States Constitution and in Article 1, Section 3 of the Tennessee Constitution. Individual religious liberty, in fact, was a priority long before 1775. I would call to mind the Mayflower and the travelers on that ship seeking religious liberty, the Huguenots, the Waldensians, and innumerable others who came to this country in search of religious liberty. A core of that religious liberty is the individual's determination of what their beliefs are. In the bill, the term medical procedure specifies products authorized for emergency use. And I want to emphasize to you, contrary to some other bills you may have seen, this one is aimed at emergency use. An employer must provide reasonable accommodations for employees with an exemption. Reasonable accommodations do not include firing somebody who refuses a vaccine. They do not include cutting back the hours of an employee who refuses vaccines. If employers have bona fide questions under this bill, they can request a signed affidavit. But they cannot, of course, require a signed affidavit as routine for every employee that claims that. They must have a reasonable suspicion. I will point out to you that under the Nuremberg Code of 1947, forced vaccinations are illegal under international law. By definition, an emergency use procedure is just that. It's emergency use. 21 U.S. Code 360 BBB 3E 1A II, in fact, says that emergency use vaccines, medicines, procedures are not to be forced on people. In fact, that that principle was upheld in federal courts as recently as 2003. Case was John Doe versus the plaintiffs, which included Donald Rumsfeld and the Department of Defense. That citation is available if you want it. But the point is straightforward. I'm sure all of you have, if you haven't been present in a church service or haven't seen one on television or in the movies, where someone walks up to accept a conversion, their religious principles at that point change. And it's their right to do that. It's not an employer's right to question that. If they go to their employer and say, I have religious objections to this emergency use procedure, That should be the end of the argument, period. The employer should not have the right to say, well, I have to check into this and see if your religious objection is really valid. With that explanation, ladies and gentlemen, I sincerely ask for your support on this bill. Thank you, Mr. Chair. I stand ready to answer questions.
Thank you, Chairman Reagan, for this explanation. Do we have any questions for the sponsor? And Chairman Parkinson. Representative Parkinson.
Chairman Parkinson.
Yes, sir.
Chairman of the Black Caucus. just give me a hard time, Mr. Chairman. Just give me a hard time. And Chairman Reagan, just got a quick question. How does this intersect with the fact that Tennessee is an at-will state?
Chairman Reagan.
There are two different categories here. First, an employer, there is an expectation on the part of an employee, even in an at-will state, that they have a continued employment barring some reason. If the employer chooses to let the individual go, the employer has that right to do it, but it's not arbitrary. The employee has a right of action if it's proven to be arbitrary.
Representative Parkinson.
I have nothing else. That was my only question. Thank you, sir. Thank you.
Does anyone else? Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And I do have to give you props. I think that's the first time I've heard French Protestants from the 1500s, Calvinists at that, referenced in a committee in the Tennessee legislature. So props on that one. I do have follow-up on the question of my colleague here with regards to at-will employment. The essence of at-will employment laws of the state of Tennessee give an employer the right to terminate individuals for any reason except for a select class of protected classes. How does this bill, which really usurps the authority in at-will employment laws with regards to private employers, how do you justify this or make it agree with the spirit of the at-will employment laws of the state of Tennessee?
Chairman Reagan.
Thank you. Straightforwardly, we're talking about protected classes. We're talking about the freedom of religion. As I mentioned, the First Amendment, Article 1, Section 3 of the Tennessee Constitution specify freedom of religion. By the 14th Amendment, the First Amendment applies even if we didn't have it in our own Constitution. And therefore, the at-will employment piece of this, if the employee is let go because of religious beliefs, puts them into that protected class.
Representative Clemens.
And you know, we had a bill previously, I believe it was brought by Chairman Zachary. How does this, that came before this committee, how does this bill overlap or agree or contradict or contrast with that legislation that was already passed?
Chairman Reagan.
This bill is aimed specifically at emergency use medical procedures. Pure and simple.
Representative Clemens.
I see the bill in front of me in subsection C and B and the whole thing. So your definition of medical procedure is specifically by an emergency use authorization from the U.S. FDA. Is that correct?
That, sir, is Section 1A, subparagraph 3.
Okay. And I'm sorry, Mr. Chairman.
Oh, you're fine, Representative Clemens. You're recognized.
Thank you. And so what, the same question I asked Representative Zachary, what religions prohibit the use of a medical procedure? Any specific religions?
There are several, sir. But most specifically, I'll mention Christianity. Certain sects of Christianity maintain that the human body is, in fact, the temple of the Holy Spirit. And it is within the realm of religious objection to avoid putting something into that temple that they consider to be profaning it.
Representative Clemens.
Thank you. And would you be referring to French Protestants from the 1500s?
Well, I have to confess, some of those are in my ancestry.
Okay. Probably many of ours. Well, I've got concerns here with, if an employer wants to make a decision that they deem is in the best interest of their business and their public safety and the health and welfare of not only their employers, but their employees, but their customers, I think we've already addressed this with other legislation. So I have concerns about it. I understand your intent and your limitation to emergency use authorization, medical procedures, but this is it seems to be problematic given the fact that I've yet to hear of a complaint about a religious exemption on this with regards to any specific religious exemption or any being denied in the state of Tennessee. Have any lawsuits been filed at this time on this aside that have moved forward?
Chairman Reagan.
The answer to your question concerning lawsuits, I don't feel qualified to comment on statewide, but I will tell you that within my district, which has two major federal reservations, or a major federal reservation with two major employers on it, that I have received numerous complaints from contractors who insisted, that's contractors to the federal government, who insisted that their employees undergo these experimental use authorizations or lose their employment. Now, some of these contractors said, well, we're making an accommodation. We're putting you on unspecified leave until such time as you decide to get it. That is, in fact, constructive termination. They're no longer getting paid. They can't support their family. Several others have come right out and said, I had a religious objection. My employer just didn't recognize it. They said, we don't recognize that religious exemption. And that goes back to the first point I made. The idea is that freedom of religion is not what your employer says your religion is. It's what you say it is. And from that standpoint, the answer to your question straightforwardly is yes. And if you want, I could bring a parade of witnesses in here to tell you about it, because they're in my district.
Representative Clemens.
Thank you. I'd be interested in hearing from them. Thank you, Mr. Chairman.
Thank you. And we're going to go out of session real quick just to clarify if there's any confliction between this bill and House Bill 1867. Without objection, legal is recognized.
Michelle Fogarty, Legal Services. For clarification, House Bill 1867 states that an employer that requires a staff member to provide proof of vaccine or to receive the vaccine shall grant the staff member an exception if the staff member attests in writing that they have a sincerely held religious belief. And it also states that the employer cannot ask for any additional information or proof beyond the staff member's initial statement. House Bill 2117 provides that the employer must grant an exemption to the policy if the employee has a religious objection to the medical procedure, but it does allow the employer to request the employee to provide a signed affidavit if they feel that, if the employer has a reason to question the sincerity of the employee's religious objection. And House Bill 1867, as I said, applies to the COVID vaccine. It doesn't specify the emergency use authorization or post when it's been approved by the FDA. It's just the COVID-19.
And Representative Parks, is that for legal? Yes. Okay, you're recognized for legal.
Thank you, Mr. Chair. And Counselor, how does the bill that we are hearing now fit with the language that's in statute, I guess, with the federal government?
Legal, you're recognized.
I believe under Title VII, a religious exemption is allowed, and an employer can make reasonable accommodations. However, I believe it also says that if an employer can't make reasonable accommodations, then they can discharge the employee.
Representative Parkinson.
Thank you, Mr. Chair. And with the request for the affidavit, is that going beyond what the federal government is saying in their language, or does that? I'm just asking because I don't know.
I think that's acceptable under Title VII.
Okay, thank you. Mm-hmm.
Anybody else for legal? All right, Chairman Farmer.
And thank you, Mr. Chair. And I'm just curious, I'm just thinking through a situation where you have a contractor that enters into an agreement with the federal government. And within that agreement, there's certain things that they have to comply with and follow, right? Then we have an employee that comes in and says, well, I have a religious exemption. It's a valid exemption, right? Tells the contractor, say, well, and the contractor says, I'm going to try to make some reasonable accommodations for you, but I'm, under my agreement with the federal government, I can't, So how's it conflict with, how's that going to work? I mean, are we going to come in and sue the contractor though the contractor will lose their bid? I mean, how's that work with regards to the federal law and the state law?
Legal,
Does it conflict there?
I think under Title VII, an employer is only required to provide an accommodation that does not place more than a minimal cost on the employer. And if no accommodation in that respect is available, then the employer can take adverse action against the employee, such as discharge them, fire them. And I would think federal law would prevail over state law.
Chairman Farmer, you're recognized.
So does that contractor, is the contractor in this situation covered under federal law or state law?
Legal, you're recognized.
I believe if he has a contract with a federal employer, that he's governed by federal law.
In the hypothetical where a lawsuit's filed or something happens, then what, you file a motion to dismiss and it goes away? Or, I mean, I know that's a big hypothetical there, but I'm just wondering if this law, I mean, is this going to, I mean, what's it going to do? I mean, how do we, and I understand what, Chairman Reagan's trying to do here, but what does it really do with regards to once a state law conflicts with federal law in this situation?
Legal, recognized.
I believe under the Supremacy Clause, federal law prevails over state law.
Okay,
So,
thank you.
Anyone else for legal? Seeing none, we'll go back in session. And Representative Garrett.
Thank you, Mr. Chairman. Thank you, Chairman Reagan, for bringing this legislation. Obviously, we want to make sure we keep our federal government from reaching too far. I think the Supreme Court said that they can't force the vaccine, even using the agency of the federal government through OSHA. But my question, even though I think I support your legislation, I just want to make sure I'm got it clear in my mind. You've got medical procedure defined means a drug, device, or product. And so we all can understand that the COVID-19 vaccine is an example that we can use. That vaccine was approved through various different pharmacy companies for emergency use, and then people were made to take it. So in this situation, if you've got a medical exemption in a COVID-19 vaccine scenario, you don't have to take the vaccine if your legislation becomes law. I guess my question is, a drug, device, or product, can you give another example besides the one that we all know with the vaccines that this might apply in an emergency use situation where an employer might make someone either go through a procedure or a device or a product? I'm a little bit concerned of how broad that is. Can you enlighten me a little bit?
Chairman Reagan.
Thank you. This language was lifted right out of the federal document, so the drug, device, biological product is intended to cover not just vaccines, but a hypothetical example may be an employer requires someone to wear some sort of contacts or something in their eyes because of a certain situation, and that's an experimental use approval, or pardon me, emergency use approval. That would be an example. The point is that bodily integrity is one of the basic liberties that has been in common law since common laws existed in the British Isles. And the point behind this legislation is to say that threatening someone with a loss of livelihood is coercion if you don't do what I want you to arbitrarily. By definition, emergency use makes it arbitrary to some degree or the other. The point that was made earlier about accommodation, discharging or threatening to discharge an employee is at the bottom of the list of accommodations, assuming they have not been able to achieve another one. Again, from my constituents in my district, I had, I have to be careful here, I do not want to compromise any of my constituents. Let's just say that the largest paramilitary force in the United States of America is located in my district. Nobody knows what it is, and it's there. They have armored vehicles and heavy weapons, and it's a good thing nobody knows they're there. But they're there for a reason. They are employed by a federal contractor. Some of these employees were told, get the emergency use vaccine or you're out of here. Now, the accommodation that could have been arrived at rather easily was to say, okay, we'll put you on schedules that put you in situations where you're not in contact with other employees. You come and go, you check in remotely via electronic devices, you fill your station. That's an accommodation that does not require discharge, but they were, in fact, discharged. And that's an example, and I will not go in further detail for fear of compromising my sources. I will say there was many more than one.
Representative Garrett.
Thank you, Mr. Chairman. That's all.
Representative Griffey.
Thank you very much, Chairman, and thank you, Chairman Reagan, for bringing this legislation. I think it's important legislation. I think it's timely. You know, I never really thought we'd get to this point in America where, you know, instead of the government forcing you to do something, there's kind of seems like a roundabout way of getting employers to force people into doing something, taking a shot, injection into their body that they may or may not want to. As far as reasonable accommodation, how about this? Don't force somebody to get a vaccine they don't want. Let them take the risk. I think we were completely, all of us were completely misled as to the vaccine supposedly stopping the spread. It doesn't stop the spread. And for government and employers to push this upon citizens that don't want it, I think is unconscionable. So I'm definitely supporting the legislation. Thank you, Mr. Chairman.
Chairman Reagan, would you like to respond?
No, sir. I agree with what was said.
Okay, I've got, Chairman Farmer.
And thank you. And just circling back, Mr. Chair, and I appreciate you bringing this piece of legislation, but in your hypothetical, how would this bill change anything with those federal contractors when federal law supersedes state law?
It would
Chairman Reagan.
It would require the employer, in this case that contractor, to be much more diligent about finding accommodations. That pure and simple. The employers are not constrained purely on the basis of convenience. They're required to offer these accommodations beyond simple convenience to them. Now, in a situation where there's plenty of employees and they can let people go at will, if it's not an arbitrary situation, that's fine. But this puts, again, a protected class that has been in our Constitution since 1787, when it was ratified under the First Amendment. Created a protected class for religion. And this, in fact, is reinforcing that protected class and saying that, you know, you have to go beyond just a cursory examination for an accommodation.
Chairman Farmer.
One follow-up. Let me ask you this way: how is this state law any different than other state laws that came in conflict with federal laws?
Chairman Reagan.
I would point out, sir, that federal contractors, in fact, have a business license in our state that gives our state the authority to regulate their business in conjunction with the federal government. I don't see this as a conflict. I see this as an additional requirement on that employer to go beyond just simple convenience argument. It's not convenient for me to provide an accommodation for this employee, therefore I'm going to put them on indefinite leave, which is effectively termination. That's a constructive termination, especially with no pay. If they say we'll put you on leave and give you pay until we figure this out, that's different. Or to say to them that you have 2 weeks of continued employment. If you don't have the vaccine by then, you're terminated. The question arises, if they can give them 2 weeks, what's preventing them from giving them longer? And as was pointed out by one of your colleagues on the committee, sir, the evidence that was put forward initially with this was questionable. And it has become even more questionable in time since then. I think our citizens, our Tennesseans, should have the right to say, wait a minute, I have a religious objection, and you have to do more than just get convenient here in terms of accommodations.
Chairman Farmer.
And one more follow-up, and I agree with that. If we're sitting here, we're in the United States Congress, and you were Joe Biden or whomever, and I would pressure you to to take a second look about how you're running this country and what you're forcing Americans to do. But we're state government. We're not United States Congress. We're not the Senate. We're not the House, and we're not administration that's sitting up there in Washington, D.C., making these silly mandates, right? And I think we've gone as far as we can with regards to mandates. I mean, Chairman Zachary's bill, I mean, I think we went as far as we absolutely can, and we've went probably across the line when in the laws that we've made to try to protect the autonomy of Tennesseans and others that traverse through our state, right? So my problem is this with this bill. It's just the legal theory behind this. The supremacy clause, federal law versus state law. You know, I support the policy behind your bill 100%. But when it comes to being practical about what you're trying to do, it's unlawful with regards to, not necessarily unlawful, but it's just, I think it's going to be in conflict with federal law, right? We can pass it, but at the end of the day, what's really going to happen at the end of the day? Because this bill really doesn't focus on vaccines, as you've said, right? It focuses on other things, contacts and eyes or whatever else may be out there at some point in time in the future that we haven't seen yet, right? So my concern was the federal law versus state law. Who's going to succeed in that one? And it's going to be the federal law. So that's where I was going with that, and I don't want to beat up on your bill or anything like that, because I do agree with the policy behind it, and I do agree with individual freedoms. I don't think anyone should be forcing any government should force anyone to put anything into their body that they don't agree with. Right? Let me make that very, very clear. So thank you, Mr. Chair.
Chairman Reagan.
Thank you, Mr. Chair. And I would seal my argument with a quote from Chief Justice Roberts. It's at U.S. Supreme Court. States are sovereign, and sometimes they need to act like it. In my opinion, it's time for Tennessee to act like a sovereign state. Thank you.
Thank you, Chairman. Chairman Farmer, you got anything to follow up? Representative Ogles, you're recognized.
Thank you, Chairman, and to the sponsor. I commend your efforts on this. I believe you and Representative Griffey and some of us back during special session brought this up and thought that this was the only way for us to have a firm footing to push back against these mandates. And I did have a question to you. We keep talking about supremacy clause and conflicts with federal law. To my understanding, there's been no federal laws passed. We're dealing with mandates within administration, rules that were made during within one department as far as the OSHA regulations, and then we're talking about federal contracts, which are not laws. It's not a law that's gone through Congress. It's not a law that was voted on. It didn't go through both chambers. It wasn't signed by the president. We're talking about mandates within government bureaucracy. To your knowledge, has there been any laws passed to mandate vaccines?
Chairman Reagan.
Once again, thank you for that question. Quite the opposite. I cited two examples, 21 U.S. Code 360 BBB 3E 1A II, and the court case of John Doe et al. Plaintiffs versus Donald Rumsfeld et al. Defendants, 2003. To the points that have been raised, we have firm legal foundation for this bill if we choose to accept it. Now, I'm not saying it wouldn't be challenged. We wouldn't have to say to a judge in some court somewhere, we, the state of Tennessee, see it this way. And as points were made earlier, mandates with quotation marks around them that are not public law, meaning they have not gone through Congress, they haven't been gone through the Uniform Administrative Procedures Act, are not law. And we shouldn't be forcing our citizens, whether that's being enforced by an employer or anyone else for that matter, to violate their religious convictions. The First Amendment and the Tennessee Constitution, Article 1, Section 3, in my mind, reigns supreme. Thank you, Mr. Chair.
Representative Ogles.
Thank you, Chairman. I support the legislation. I'm ready to vote on it.
And Representative Parkinson.
Thank you, Mr. Chair, and you know everybody won't get this, but we military folks. But you still have your military cadence coming through. I just want you to know that. But also here's what in my estimation could be creates a challenge for me too. So, and when Chairman Zachary brought his legislation, I mentioned, the possibility of frivolous applications for religious exemption being brought forward, and I used the example. And sorry, Mr. Chair, if I'm out of order for using my hat, but if I worship hats, right, and I say, hey, I worship hats, shouldn't have to take this shot, shouldn't have to, I should be exempted from the shot. Under this legislation, then the only recourse that employer has, and well, for those of you that don't worship hats, that employer may look at this as, this is a crock, right? And one thing, it creates this space of having an employee who lacks integrity, right? That you have to now get an affidavit from, right, and keep that person employed. And for all of those businesses out there, and all of those employers, in our state, whether that's small business or large business, micro business, now they are, if they say, that I've never seen a service where they put the hat on the altar and everybody goes down and bows before it, right? And he says, I'm not accepting that. Now there's a cause of action against this employer, or this business, and he can rightfully be sued because we are actually creating a cause of action for him not accepting this religious exemption of hat worship. And so I'm not sure if that's what we want to do, in this regard. Now, Chairman Zachary's bill, while it spoke to the language that or the mandate, if we're calling it mandate, whatever we call it, but it spoke to the language that was within, that came from the federal government, but it didn't go past that and put our employers, rather, or our businesses, especially those small businesses. I'm a small business owner. And I'm thinking about those groups, especially, in a situation to where now anybody can come up with anything and say, this is their mode of worship, and now they can actually sue that business under this legislation. So that's my concern. I mean, and, you don't have to respond to. You can if you want to, but that's what my concern is about the bill. Thank you, sir. Thank you, Mr. Chair.
Thank you. And I will choose to respond. I'm glad you brought up the example because it brings to mind my service in NATO, where I served with British and French and Germans and so forth. And in particular, I'll mention the British. They have Sikhs in the British forces, and they, in fact, are required by their religion to wear turbans. They have an accommodation. In fact, that same accommodation exists now in our own U.S. services. So hat worship is indeed recognized. But to the point that you mentioned, religious freedom does not exist on what someone else thinks is reasonable. Religious freedom exists on what you, as an individual, accept as your religious beliefs. If you're worried about lawsuits, that's why we have courts. They settle disputes. And I'm not afraid, quite frankly, for our state to defend itself in court. I go back to Justice Roberts.
Representative Parkinson. Okay, I've got a couple of questions, not seeing anyone else. So this just covers emergency use?
That is his point, yes, sir.
Okay, so right now there's 3 vaccines, and one of them's been taken off the emergency use. How will this bill be effective for that one vaccine?
If it's not an emergency use medical procedure, it falls into the same category as measles, mumps, rubella, polio, etc. So this bill does not address that.
So right now, with Pfizer being usable, not on the emergency use, this bill wouldn't affect that entity that you was talking about, and they can require their employees to get the shot.
I would say if it's not an emergency use vaccine, yes. Pfizer's vaccine, Comirnaty, I believe is the the one that was taken off the emergency use, is not been made available. The stocks that they have in supply at this time, is my understanding, and I will confess my research is a couple weeks old, but my understanding is the Pfizer vaccines that are in stock are still the ones that were designated emergency use. Now, I'm willing to change that opinion on the basis of additional research, but that's my understanding at the current time. The straightforward answer to your question, though, if it's not an emergency use vaccine, this bill is not aimed at it.
And you think this bill is what we need to do, even though it conflicts with another bill that was just passed by Chairman Zachary?
I don't see it as a conflict. I see it as in conjunction with.
Okay. Seeing no further questions, we'll vote on House Bill 2117. All those in favor signify by saying aye. Aye. Opposed, no.
No.
The noes have it. Bills fails.
Thank you, Mr. Chair and Committee.
Next up is House Bill 1018, Chairman Halford. We've got a motion and we have a second. And Chairman, I show an amendment. Do you want to run that amendment?
Actually, Mr. Chairman, this is a cleanup bill from years ago. So I'm assuming that the amendment is already there.
If I understand correctly, the amendment just changes the effective date. If you still want to go with that amendment, I just need the drafting code.
I'm sorry, sir, I don't have the amendment. Drafting code 13846.
That's it. We have a motion and a second. Those in favor of adding amendment 13846 signify by saying aye. Opposed, no. Amendment added. And Chairman Halford, you're recognized.
Mr. Chairman, thank you again. As I understand this, this bill, this actually, I inherited it from a member that is not here any longer. It actually passed the House first time in 2019. In 2019, there were some provisions left out. For instance, it left out the 4-year background check and the renewal fee language there, and then it was presented again in 2020, passed the House, but it never passed the Senate, so actually it was never heard in the Senate. So we're here today to add those two provisions back into the bill as it was passed in 2020, which would include the 4-year background check and the renewal fee.
Thank you, Chairman. Any questions for the Chairman? Representative Clemens, you're recognized.
Thank you, Mr. Chairman. Yeah, I was curious if we're going to hear from the Department of Safety as to how this overlaps with the bill that we previously passed.
Chairman Halford would.
Yes.
Okay. We'll go out of session here from Department of Safety. Out of session. And Ms. Stroker, if you'll just identify yourself for the record.
Elizabeth Stroker, Legislative Director for the Department of Safety. And Representative Clemens, the bill that was passed, I believe you're referring to Representative Bricken's bill, that only deals with enhanced handgun permits. This one cleans up the concealed permit code back when it was passed. There wasn't a mechanism for renewal, and then it left out the 4-year background check, and so it just adds that language in to make it consistent.
Representative Clemens.
Thank you. I appreciate the clarification. Thank you, Mr. Chairman.
Anyone else for safety? Seeing none, we'll go back and Representative Griffey, you're recognized.
Thank you, Mr. Chairman. So my question is this: if we don't pass this bill, what does that leave it with the concealed carry permits?
Safety, you're recognized.
Yeah, so if we don't pass the bill, either the renewal fee would have to be the full amount of the permit itself, just because there was no price put into the bill. It was just an oversight, so it just matches up with the renewal for enhanced. And also, if we don't pass it, then we wouldn't be doing that 4-year check as we're required to do with the other permits that we have. So if we don't pass it, those two things just wouldn't be able to be done.
Thank you, Mr. Chairman.
Anyone else for safety? Seeing none, we'll go back in session. And Chairman Hoffer, you're recognized.
I renew my motion.
Okay, we got a question on the bill. All those in favor to move House Bill 1018 to civil full signify by saying aye. Opposed, no. Bill passes. Congratulations, you're going to Civil 4.
Thank you, members.
All right, next up is item number 3, House Bill 2770 by Representative Todd. We got a motion and a second. Representative Todd, you're recognized, and I do not see any amendments.
We have no amendments, sir. Thank you for that. Thank you, committee, for this opportunity. I'll start by just relaying an experience I had just a few years ago. I have been a longtime blood donor in my local community, and one day I went in to donate and noticed there was a posting on the door that was the legal posting, no guns allowed. It's a gun-free zone. And I immediately went to the CEO and had a conversation with him about the lack of security. He had no security that he was providing in this facility. And my point to him was, you've asked me to come in here and donate a product that you make money off of and you do business off of, yet you are asking me to leave my personal protection that I have a right under the Constitution to carry and to protect myself. You're asking me to leave that in my vehicle or at home in order to come into your business and do business with you. And you provide me no protection whatsoever after giving up my own personal protection. And he understood, and he had some staff that were just uncomfortable with folks possibly concealed carrying in their facility. And at that point, I walked out. I didn't come back until he was gone and that sign was removed. I've now resumed that donation process because they've realized the error of their ways, that they're asking folks to do something that's against their constitutional rights. And so what this bill does, it addresses that by saying that any person or entity that posts their property as a gun-free zone according to the Tennessee Code must provide some security, some protection for that person. And they are also creating a cause of action if that person is injured and are not able to defend themselves. So that's, I can answer questions, but this is not dealing with criminals. That's been one misnomer. We don't legislate for criminals in this legislature, as you know. We legislate for law-abiding citizens. So what this does is takes one more infringement off of folks' right to bear arms, keep and bear arms, and protect themselves from bodily injury or harm, but also protect themselves from tyrannical governments, as we're seeing around the world. That right is inherent in the people. And we have infringements right now on the books, and this just helps clear up one of those infringements that I believe needs to be taken care of for the protection of our citizens.
Thank you, Chairman. And members, we've got a couple people to testify. We'll get them up here first, and then we'll go for questions after that. And first, the Department of Safety. Ms. Stroker, are you still here? And she stepped out, so we'll go ahead and go with Brian. Okay, Ms. Stroker, would you like to come up here? And you got 3 minutes, and we'll go out of session.
Yeah, this definitely won't take 3 minutes. Department of Safety, Elizabeth Stroker. We probably have concerns that's similar to everyone else. It's just what this liability may actually impose on the department. Obviously, there are a lot of facilities that the department has, and really all state buildings have, that prohibit the carrying of firearms. And it could be just because not through any requirement of our own. We have, some service centers that are in strip malls or in property owned by other people that prohibit the carrying of firearms. And so we're really concerned with that liability, knowing that it's something that's out of our control, especially for a state facility.
Thank you. And any questions for safety? Representative Clemens, you're recognized.
Thank you, Mr. Chairman. So just hypothetically, so if somebody goes to a DMV and they get impatient because they're having to wait at the DMV, like we tend to have to wait, and they decide to start shooting up the place, anybody in there who's injured can then sue the state of Tennessee for prohibiting firearms in that facility under this bill?
Ms. Stroker.
That's correct, but a few clarification points there. One, our wait times are getting better, so hopefully they're not as bad there. Much better. The second thing is we currently do prohibit firearms. No one is aggressively checked, but we do have some of our facilities where we do have to keep a commissioned officer within them because of those situations that happen. In some of our more metropolitan areas, we do have to keep a commissioned officer, and they regularly have to remove people from the facilities and things of that nature. So which is one of the reasons why we don't allow carrying of firearms into our facilities, just because of that nature of people getting a little aggressive. And so that would open up the state for liability in that situation.
Representative Clemens?
And is there any exception in here for facilities that provide security to protect individuals inside that facility?
Ms. Stroker?
I think the only exception is for if it's required on a federal level. I think that was the only one, but there's no type of exception just for state buildings or if the building already has its own protection.
Representative Clemens?
Thank you, Mr. Chairman. And so Tennessee taxpayers would be on the hook for that civil action if a judgment was found in the plaintiff's favor.
Ms. Stroker?
Correct, yes, the state would have to pay it.
Thank you, Mr. Chairman.
And Representative Parkinson?
Thank you, Mr. Chair. And Counselor, if right now you have a sign that says no firearms allowed, correct?
Ms. Stroker?
That's correct. We do not allow firearms in any of our facilities unless you're a law enforcement officer.
Representative Parkinson?
Thank you, Mr. Chair. And so let's reverse this. Let's say you did not have a sign up there that said no firearms, and people are coming in with their firearms, and someone decides to shoot the place up. Are you on the hook in regards to that facility for possible causes of actions for those people that have been harmed in a situation like that because you didn't have a sign up there, possibly?
Ms. Stroker?
Legal could correct me, but I believe there's already a provision in code that holds harmless an entity that doesn't prohibit firearms within their facilities.
Representative Parkinson?
Oh, thank you.
Thank you.
I'm getting a nod from legal, so okay. Thank you for that.
Anyone else for safety? Representative Griffey?
Thank you, Chairman. I just fundamentally disagree with the point of view that our citizens are going to be left safe if we allow people with firearms. I think history has proven time and time again, the more people, good people, that use their constitutional right to protect themselves and other and carry a firearm, deter crime and deter bad behavior. So that's all I would say. Thank you.
Ms. Stroker, you have anything? I've got a question, seeing no one else. Has there been any previous incidents with a person with a firearm coming into a state facility?
I don't know off the top of my head. I can figure that out, though. I'm sure the troopers would have that knowledge if it was in one of our buildings or at the Capitol specifically, but for any state facility, I'd have to do some digging. I can look into that, though.
Okay. When you said that you had some troopers in some facilities, I guess as a extra protection, what was the instances that required that to happen?
We have a few of our driver services center. I think the one most recently we had a situation at was the one in Shelby County. There was some unruly people coming into the building. It happens frequent enough that we have an FPO, the facility protection officer, and then sometimes the 120-day troopers will also sometimes bring those into the facilities where we see a greater risk to the public.
Okay, and unruly without a weapon so far?
I would want to double check on that because we do prohibit any weapons within the facility so far, but I would want to check to make sure that the person or people were not removed because they may have brought something in. I don't know 100% on that. I'd have to look into it.
Okay, thank you. Anybody else for safety? Seeing none, we got Mr. Brian Griffin. And Mr. Griffin, you will have 3 minutes, and if you'll just state your name, who you represent, and begin, and we'll have unlimited time for questions. There's a little button there, a little red light will come on.
Now I'm on. There we go. Good. Hey, my name is Brian Griffin. I am a resident of Davidson County. I've lived here in Nashville for several years. I'm a healthcare provider for the past 17 years in the state of Tennessee. I'm also a Tennessee State certified handgun instructor. I also own a handgun safety school, Waypoint Defensive. So I would like to thank you for this opportunity because I think I represent myself, my other colleagues, my other fellow instructors, and several thousand students who have gone through my courses. Tennessee is a very interesting place, all right? The world's a very interesting place. And every day, as an armed, responsible citizen, I have to navigate a lot of weird places. I have to understand where I can carry a firearm and where I cannot carry a firearm, and I have to understand my responsibilities as an armed citizen, what I can and cannot do. And so it does bring difficulties when there are places that establish, by their own right, that they prohibit other people from carrying firearms. This can be a very tricky and difficult terrain to navigate, both for myself and my students, since firearm laws by themselves can sometimes be tricky. Every day I take the personal responsibility to defend myself and other people. I take follow-up education. I have due regard to what I need to know as a responsible citizen. And every so often I'm forced, I don't really have a choice, to enter into facilities, either to vote, go to a hospital sometimes, something as simple as getting a gas receipt because the pump outside failed and it's posted no firearms. And I have to disarm myself and enter in that facility to conduct business. That's if it was correctly posted to begin with. This naturally causes difficulties because as I have taken that day, that moment when I woke up to take the steps to defend myself, as constitutionally I'm allowed, I have to pass the buck to someone else. I have to walk into an establishment and hope that I won't be an easy target, which, based off my location, actually makes me one. I have to ensure that I have a secondary or a tertiary plan of action in case today something bad happens. And so how can I navigate that? That's why I thoroughly endorse, I approve of this legislation because I think it's a fair trade. If I have to take away my ability to defend myself, then I think it's completely fair that the responsibility for my defense can be assisted or laid off on someone else as well. Like I said, I represent myself, my students, my other instructors, and I feel like this legislation would appropriately be in our benefit.
Thank you, Mr. Griffin. That was 3 minutes right on the dot. Any questions for Mr. Griffin? All right, Representative Clemens.
Yeah, thank you, Mr. Chairman, and thank you for the service you provide. I've taken a safety, one of the long version safety class, probably like you provide,
yes, sir,
and saw a lot of value in that. And I assume you see the value in what you teach.
Absolutely, it's a fundamental concept, especially in instituting and strengthening firearm culture in the U.S. Yes, sir.
And improving safety and overall
Absolutely.
use of firearms.
Yes, sir.
And responsible gun ownership.
Absolutely.
Right. And so you're aware in Tennessee now everyone doesn't have to have that training, right? And so do you have any concerns about those who don't receive your valuable fundamental training that we agree is so important? Do you have any concerns about that with regards to this legislation?
And that's why myself and my other instructors have taken great strides to ensure that we give access to education and training as easily as possible. In fact, my company by itself provides handgun permit courses for free. We do it online, in fact. One of the reasons why we've been so successful is we've been able to outreach to hundreds, if not thousands, of people who were not previously able to receive that education. So I think it's also twofold. You have that, and you also have a sense of firearm culture in the U.S., which needs to be strengthened. And while I don't believe you can do that legislatively, I do believe you can do that culturally, and through that is education. And that is one of the reasons why we provide education, such as you're asking, pretty much free of charge to anyone who wants it.
Well, I appreciate you doing that. It would be nice if everybody had the opportunity to do that, and everybody who possessed a firearm or carried a firearm had the benefit or was required to have the benefit of that training, in my estimation. So just that lack of training is a big concern of mine, and the fact that we don't require that training. And I think that poses somewhat of a threat to private safety. And given the fact that we're, usurping private property rights here and ultimately requiring someone to, or trying to force them with legislation either to allow people into their property with firearms who are untrained to use them or untrained on that handgun, perhaps, that's very concerning to me. And so if you have any response, I appreciate it. If not, thank you, Mr. Chairman.
I completely understand your concerns wholeheartedly. The concept of training by itself is a very subjective term in nature. That's the way it is. However, we have a lot of documented stances on self-defense use with people with firearms have very minimal training, if you would like to call that, and/or education. However, this is a very easy thing to circumvent by itself. Through strengthening firearm culture in the U.S. and providing something as simple as online education that is essentially free to anyone that just logs in, we can completely fix that. On the opposite side of that, we also have to have the consideration that while it is, and I understand your concerns, maybe problematic in certain people's viewpoints to have someone who is untrained, which is a subjective term, inside their facility, it's also not very well balanced by the concept that they are still not able to defend themselves and they have no recourse for protection as well.
Thank you for that. Anybody else for Mr. Griffin? Mr. Griffin, thank you for your testimony.
Thank you, sir.
And we'll go back in session. Chairman Todd.
Thank you, Mr. Chairman. I appreciate that, and appreciate you allowing those folks to testify. On one clarification that safety forgot to mention, they alluded to it, but there is a section 6C, says that, in Section 6 it talks about this does not apply to areas that are by state law or federal law prohibited from having firearms. For example, a prison and other settings. And I've had several conversations with various departments, DHS and mental health and others, even general services, about some of the things that have been mentioned. And one of the suggestions that came out of those conversations is that we include in this language the requirement that any kind of claim on state property go through the Claims Commission. And I thought that was a very good observation, a good suggestion, and I'm certainly working on that. I do plan to have an amendment that would bring that in here, and that would make it equivalent to what we do for other injuries on state property, I believe, is my understanding from those individuals. Certainly appreciate the concerns. This really, one of the things that we didn't even mention here is that these gun-free zone signs that are put up advertise to criminals that there are sitting ducks going to and from these locations and within those locations. And it would be easy for a stalker, for example, to be watching, let's say, a petite young woman going into one of these gun-free zones and be able to follow her out and attack her, knowing that she has likely no defense on her. And so that's what this is really trying to address. And it's a balance with not only our citizens' rights to keep and bear arms for our own protection, but also the property rights of the owners of the property. So we want that balance, and this, I think, strikes a balance. Right now, it's very heavily tilted toward the property owners. Many situations have already been mentioned here this morning where there's not any option but to enter. For example, the gas station receipt, he talked about how many times has that happened to us. And then certainly going into a facility that safety has, and we're required to go in to renew our driver's license, or we're required to go in and get a registration taken care of or something like that. So our government already puts us in the position where we're having to go into those places, and this just affords the protection that law-abiding citizens already have under the Constitution without a requirement for training. There is no, as you know, there's no requirement for training in the First Amendment. There's no requirement for training in the Second Amendment. Is it a good idea? Absolutely. Is there a responsibility that goes with both of those rights? Absolutely. And I absolutely agree with the gentleman that was just here that folks should take advantage of training opportunities. It's your responsibility to be trained and to use a firearm if you plan to carry. If you plan to carry a knife, you should be trained to carry a knife, and we have no restrictions on that in this state. So there's no difference. But considering that I do have these amendments I'm working on, I would appreciate the opportunity to roll this bill, and I don't know how much more time we have in this committee, but I'll leave that at your discretion, whether that's 1 week or 2 weeks.
And thank you, Chairman, for what you do to protect our Second Amendment rights. And we'll roll it 1 week. And without objection, rolled 1 week for House Bill 2770.
Thank you, Committee.
Thank you. Next up, item number 5, 2063, House Bills 2063 by Representative Manus. We got a motion. Do we have a second? We've got a second. Representative Manus, you are recognized, and I do not see an amendment.
House Bill 2063 amends Tennessee's probate statutes to remedy an oversight made in legislation that we adopted in 2021 when the homestead exemption was increased. At that time, it was increased from $5,000 to $35,000, but the caption of that bill was not broad enough to capture the probate homestead exemption. The homestead exemption is most frequently applied in bankruptcy and civil collection actions to protect a certain portion of the debtor's equity in their principal place of residence from the claims of creditors. This bill simply corrects the amount for the homestead exemption in probate proceedings so that it reflects the same amount that the General Assembly adopted in 2021. I understand this was the original intent.
Thank you, Representative Manus. Any questions for? We got a question on the bill. All those in favor of House Bill 2063 to go to civil full signify by saying aye. Opposed, no. Civil full. Bill passes.
Thank you, Mr. Chair. Thank you, committee.
Thank you. Next up, House Bill 1898, Representative Grills. Representative Grills. All right, we'll roll that to the hill. Next up, 2596, Representative Hodges. We got a motion and a second. Representative Hodges, I show an amendment. Do you have an amendment?
Yes, Mr. Chairman, the amendment makes the bill.
What code do you show on that?
013413.
Okay, we got a motion and a second on the amendment 013413, and we're voting to add to House Bill 2596. All those in favor signify by saying aye. Opposed, no. Amendment added. You're recognized, Representative Hodges.
Thank you, Mr. Chairman. So what this does is it just protects a private landowner if he donates or leases his land to a government entity that then runs a greenway through that property, that he won't be held liable for any injuries on that property. With that, I'd be glad to take any questions.
Any questions for Representative Hodges? We got a question on the bill. Those in favor of House Bill 2596 to go to civil full signify by saying aye.
Aye.
Opposed, no. The ayes have it. Congratulations, civil full.
Thank you, Chairman and Committee.
Next up, item number 10, Chairman Farmer, House Bill 2443. Do we have a motion? We got a motion and a second. Chairman Farmer, you are recognized on House Bill 2443.
Yeah, thank you, members. And what this bill does is currently if you evict someone from a property that you own as a landlord for lack of paying rent or failure to pay rent, and they want to appeal that, they have to post a bond to do so. And what this bill does is allows for, if you evict someone for something other than paying rent, then they'd also have to post that same bond. I think it was just something that we had intended to do as a legislature back when this was passed, and it's just making everything fair. So I'd move passage.
Very good. Any questions for Chairman Farmer? We got a question on the bill. We're voting on House Bill 2443 to send to civil full. All those in favor signify by saying aye. Opposed, no. Congratulations, you're going to civil full. All right, that brings us back to item number 6, House Bill 1898 by Representative Grills. We got a motion. Do I hear a second? We got a second on House Bill 1898. Representative Grills, you are recognized.
Thank you, Mr. Chairman and Committee. This bill is attempting to harmonize what most of the public think is already in law. I'm simply wanting to expand the handgun permit to a firearms permit so that the individual can not just carry a handgun, but also a long gun. There are 37 states that currently allow the carrying of long guns without a permit, and my proposal is with a permit.
Thank you, Representative. We're getting questions for Representative Grills. Representative Clemens.
Mr. Chairman, there was an individual who was scheduled to testify today, but she woke up this morning ill and she's unable to provide her testimony. Would it be possible for me to read her testimony into the record? I think she had been on the list. She's just unable to be here due to an illness.
That's fine.
Thank you, Mr. Chairman. And I will be reading the proposed and prepared testimony of Ms. Carol Frazier in opposition to HB 1898 before the committee. She says, good morning. Her name is Carol Frazier, and sorry she can't be here today, but she represents Moms Demand Action of Tennessee, a gun safety and gun violence prevention organization with a purpose to lower the death and injury rate from shootings in the state of Tennessee. We support legal gun ownership, training, the demonstration of competence, and proper storage. HB 1898 would allow anyone with an enhanced carry permit to openly carry any firearm he or she legally owns. Currently, these permits apply to handguns only, not long guns. If this law were to go into effect, anyone with an enhanced carry permit would be able to carry loaded long guns. We openly oppose changing this law. Their objections are practical. As parents and grandparents, they worry about what we'll tell our children when they ask about a military-style long gun carried by someone they see at the grocery store. As engaged citizens, how will it feel to encounter someone armed with a long gun on the sidewalk outside a neighborhood polling place? Should exercising our right to vote be this intimidating? They also think people openly carrying long guns in retail areas and shopping strips will not be good for business. Some people, perhaps a great many, will just turn around and find somewhere else, perhaps somewhere safer to shop. People will be afraid because they won't know if people carrying long guns are responsible gun owners or people who haven't been to the range to practice in forever. Fearful that the gun will be dropped, will fire, and someone will die. For the most part, law enforcement and the public do not like open carry of firearms in public places. Should this bill pass, law enforcement officers arriving at a mass shooting will not be able to tell the offending shooter from others on the scene who might be carrying long guns. This is what happened in Dallas in 2016 when 5 police officers were killed, 9 others were wounded, and 2 civilians wounded. Law enforcement officers struggled to distinguish between the shooter and other armed civilians. Afterwards, both the police chief and the mayor said law enforcement couldn't tell, quote, good guys with guns, end quote, from, quote, bad guys with guns, end quote, because it's perfectly legal to walk around in public with an exposed long gun in Texas. As parents and caregivers, we're experts on human nature. We've raised human beings and made our share of mistakes. We sometimes run red lights or drive too fast with the kids in the car. Of course, we don't mean to mess up, but we do. Thankfully, most of our mistakes don't lead to a fatal tragedy. Access to a firearm, whether concealed or open, handgun or long gun, just increases the inevitability that someone will make a mistake and in the heat of the moment do something incorrect or stupid and someone will die. This bill increases that risk, and indeed the risk to the health and safety of all Tennesseans. Article 1 of the Constitution of the State of Tennessee says that the government was instituted for the peace, safety, and happiness of Tennesseans, which is a very good measure to view all bills coming through this committee and this assembly. Please vote against HB 1898. Thank you, Mr. Chairman, and that is the testimony of Ms. Carol Frazier on behalf of Moms Demand Action Tennessee. I appreciate your patience and willingness to read that into the record.
Thank you, Representative Clemens. We've got a couple people that's here to testify. Let's go out of session and hear from them first. All right, Mr. Griffin. It's just like the last time, 3 minutes, and just introduce yourself to the committee again and take off.
Now I know where the on button is.
Yes, sir.
So we're making progress. Once again, my name is Brian Griffin, resident of Davidson County, healthcare provider for 17 years, handgun instructor for the state of Tennessee, and own a firearm safety school in the state of Tennessee. We champion constitutional carry in the state of Tennessee, and we want to promote that as much as we can. We find that very endearing, and we think this is something that also helps us protect ourselves. However, it's very interesting that constitutional carry, for some reason, only extends to handguns. Long arms are the best way for any citizen to defend themselves. They are arguably safer, more accurate, and more easily used and manipulated by anyone of any demographic, physical body type, or age. It's also interesting because since we passed constitutional carry, there's a lot of people who don't understand the full intent of the rules and the laws, and so they do walk around with loaded long arms. That existed prior and during the current legislation. So a lot of people unknowingly are creating themselves in a awkward situation because there is no rule, there is no law that actually legalizes the use of a long arm, except for when you're hunting. So people accidentally cross this line simply by carrying their loaded bolt-action rifle, for example, to and from their home to their car or from their car someplace else. And this also complicates other issues as well, because if they cannot carry that loaded long arm, they're forced to keep it in their vehicle, and we all know exactly how difficult and problematic that can be as well. So we look back at these things and we try to figure out exactly how we can manage this in a forthright and educational context. There's about a little over 40 states right now that automatically have some permit system or legislation that allows long arm carry, and I think this will be an excellent tool for citizens of the Tennessee and my students to adequately defend themselves as well.
Thank you. Any questions for Mr. Griffin? I've got one. Mr. Griffin, do you teach handgun safety for long guns also?
Yes, sir, I do.
Okay, thank you. And seeing none, that's all we've got for you. We'll call up Department of Safety next. Thank you. And Ms. Stroker, are you still in the room? Welcome back. And if you'll just identify yourself again to the committee, and you'll have 3 minutes. Thank you.
Elizabeth Stroker, Legislative Director for the Department of Safety. While I think everyone here knows that the Department of Safety is just, against the idea of allowing long guns in general as opposed to just handguns, just due to the safety aspect of that. However, I know that what the intent of the sponsor is to do that, and so I wanted to focus on the issues with the bill as written, with the fact that it doesn't exactly do kind of what the bill is intending to do. It gets rid of the reciprocity for other states because it removes some language from the reciprocity code to where it would only allow for a handgun permit from another state and not any type of permit from another state. It also, the temporary permit code only allows for handguns, and so it would prohibit any type of carrying except for a handgun for those issued with a temporary permit. It also doesn't change the surrender statute to handguns as well, and so it could be interpreted that if you have a long gun or a firearm permit, you would not have to surrender your permit if you were required to do so under the revocation laws on both state and federal level. Another issue is that the posting statute also isn't changed, so there's a lot of inconsistency with how businesses or government would have to post to prohibit firearms because it would be dependent on what that sign has to say and how that sign reads, because right now you can do dependent on the type of permit, and obviously it would be any type of handgun. And so that code would also need to be fixed to match what this is doing as well to prevent any inconsistency. Another big issue is that it doesn't change the law for carrying while you are impaired or intoxicated. It says that you cannot carry a handgun, even with a permit, if you are consuming alcohol or drugs. That word has not changed, so you could, in theory, with this bill being passed, carry a firearm while you are intoxicated. The revocation code also needs to be cleaned up as well because, again, and this is, I know this may sound repetitive, but a lot of the code references handguns because we only have a handgun permit. And so a lot of it is now inconsistent or it cannot be used or would allow for one person to carry one type while not carrying another type of firearm, even if they would otherwise be prevented to. And so kind of a massive overview of if this is the route everyone is wanting to go, there needs to be a lot more work done on the drafting of this because as written, it is not consistent with the rest of state law because of just changing handgun permit to firearm permit does not fix all of these other issues. Lastly, the handgun code, the permit course requires that we teach handgun information. Do we now need to adopt that and allow for range training for long guns and teaching for long guns? And that's not clear either. And so, again, just another factor to consider. And so I'll kind of wrap up there, but there's just a lot of legal inconsistencies within the bill itself.
Thank you, Ms. Stroker. Anybody for safety? Representative Griffey.
Thank you, Mr. Chairman. Thank you, Ms. Stroker. Did you get with the sponsor about Department of Safety's objections and try to work out some of the language tweaks or whatever?
Ms. Stroker.
We met with the sponsor last week, and then I couldn't get a meeting before this committee for the rest of it, but we did let him know kind of what these other issues are that would definitely need to be worked out. But even if these issues were worked out, I don't think it would make safety comfortable with the bill, just flat out moving it to long guns in general, or any firearm.
Representative Griffey.
Are long guns any more dangerous than handguns?
Mr. Stroker.
Something makes them especially dangerous? I mean, they're both shooting a projectile based on an explosive propellant.
Ms. Stroker.
I am not an expert on which guns are more dangerous than others, so I do not feel comfortable answering that question.
Thank you, Mr. Chairman.
Thank you. Anybody else for safety? And seeing none, we don't have anybody else to testify today, and we'll go back in session. Sponsor, you're recognized.
Mr. Chairman, I would, Mr. Toby Meyer, he was turned in to potentially testify. So.
You are correct. So we'll go back out of session and hear from Mr. Meyer. Mr. Meyer, you'll have 3 minutes if you'll just identify yourself, who you represent, and take off.
Yeah, thank you for giving me the opportunity to
speak and address a few questions. My name is Toby Meyer. I'm with T-Rex Arms. I very much support this bill because it actually does bring, as the sponsor said, Tennessee law in line with what the law already is in the vast majority of states in the United States. For example, our neighbor to the south, Georgia, where I used to be a resident for a while, does not issue handgun carry permits, but issues weapons carry licenses with which you can carry any weapon that's not prohibited under federal law. Georgia has both more rural areas, forests, and vast swaths of land that are sparsely populated, as well as population centers such as Atlanta that are much more densely populated than the biggest population centers that we have in Tennessee, Memphis and Nashville. And Georgia has not had any problems with allowing carrying loaded long guns, as well as any other state hasn't had any problem that does allow carrying loaded long guns. What's also important is to notice that this bill does require a permit. So the training issue, I think, is being addressed with this bill. As far as the other concerns are concerned, I mean, I think those could be addressed with an amendment. But I very much support this bill because what I think we should not do in Tennessee is criminalize behavior that people don't think is a crime. And I think the average person, after the media coverage last year about constitutional carry, believes that it's lawful to carry a firearm. And right now, there is no way for a person who wants to carry a rifle to do so lawfully. You know, it would be a different thing if we had a specific long gun carry permit or a rifle permit or anything of that nature, but we do not. So we are one of, I believe it's about 10 states, if that do not allow carrying loaded long guns at all. And yeah, I very much support decriminalizing behavior that people don't think is a crime.
Thank you, Mr. Meyer. Anybody for Mr. Meyer? Any questions for Mr. Meyer? Seeing none, thank you for being here and thank you for your testimony. You're welcome. Sponsor, we got anybody else that I may not have on my list? All right, back in session. And Representative, you are recognized.
Question on the bill then, how about that?
So we got any questions for the sponsor? I've got a couple. What about the issues that safety said about being intoxicated while having this weapon?
No, thank you, Mr. Chairman, for the opportunity to answer that. We talked about that earlier. I believe it's already illegal to be walking down the street intoxicated. Is that not correct? Is that correct? And I don't believe you can just walk down the street intoxicated. And if you are carrying a weapon, walking down the street intoxicated, then that bill does not necessarily deal with intoxication, but this bill does not, other than carrying the weapon.
We can go out of session, that's legal, but I'm pretty sure. But Chairman Farmer, would you like to be recognized before we do that?
Just recognize when we go out of session, Mr. Chair.
Okay, thank you.
Thanks.
Out of session, legal, you're recognized.
Could you restate the question, please? Michelle Fogarty, Legal Services.
So the sponsor asked us if it's a crime to go down the street intoxicated, and I don't believe he's insinuating while carrying the gun. If you got it on you, is it a separate charge? Is that what I understand?
I believe public intoxication is a misdemeanor offense under our statutes.
And carrying
Class
a weapon, as defined in this bill, is no different than public intoxication. Is that correct? If they're intoxicated while carrying this firearm?
This bill does not amend the statute that makes it illegal to carry to possess a handgun while intoxicated. This bill does not address that statute. But if a person were to be walking down the street with a loaded long gun while they are intoxicated, they would be violating the public intoxication statute, which is a Class C misdemeanor, and they would also be violating 3917-1307 under current law if they are carrying it with the intent to go armed.
Okay, and under current law, what's the penalty for carrying a weapon while intoxicated?
It is, hold on just a second. It is a Class A misdemeanor.
Okay. Chairman Farmer, would you like to be recognized?
Yeah, I just want to follow up with legal on that line of questioning there. I think the issue is the title of the code section, right? So it says, does it say concealed weapon? What, Michelle, how's that code section titled up there? Is there a difference in firearm and what? Is it concealed handgun? Is that how the code section reads?
Which section specifically?
The one you were just referencing.
It's possession of a handgun while under the influence.
Okay, so possession of a handgun. So if we just change it, say possession of a firearm, would firearm be not inclusive of a handgun as well? Can we just change handgun to firearm in the code there, and wouldn't that solve a lot of the issues with the cross-referencing and such?
The bill changes the word handgun to firearm in numerous statutes. That particular statute was not changed in
Right.
this bill, but you certainly could do that.
Okay, would that answer would that help with some of the issues that the Department of Safety has?
I can't speak for safety.
Okay. All right, thank you.
So is the bill broad enough to cover that?
Is the caption of the bill broad enough to cover that? Is that your question?
Yes.
Yes.
Okay. Anybody else for legal? Okay, without that, we'll go back in session. So, sponsor, you're recognized to address any legal questions or the members or however you want to do it. And Representative Griffey, you are recognized if the sponsor doesn't have anything.
Thank you very much, Mr. Chairman, and thank you, Chairman Farmer. I think we could probably just do an amendment when it goes to full committee that where the word handgun is used in the code shall substitute the word firearm. And that should take care of everything. I think Chairman Farmer explained. I would propose we do that.
I think it would take care of everything, but we would have to do like we did the previous bill and roll it 1 week and add the amendment. But do you have anything else before I go to the next person? Representative Garrett, you're recognized.
Thank you, Mr. Chairman. Representative Grills, I'm reading the explanation of the legislation, and it does say that it expands the circumstances in which a permit holder may carry a firearm. And I'm curious, when I heard you explain the bill and, of course, the testimony here, it seems like we're just wanting to expand what you can carry, not expand where you can carry, but expand what you can carry from a firearm to a long gun, et cetera. So I'm curious is why didn't we just remove the word handgun and put firearm, and that's it? Could you, instead of adding what seems like some inconsistencies if we pass the bill as it is now for what we currently have, which would then create a problem later on, and you may have to come back in your bill, et cetera. So I'm kind of curious, why don't we just change that one word?
Sponsor, you recognized.
Thank you, Mr. Chairman. And Whip Garrett, I appreciate the question. That was my intention from the get-go, is just to expand what you can carry, not change where you can carry. When we took the idea to legal, this is what they gave us back. This is not a bill that was brought to me from any gun group. This was something that I asked them to draft. So if there is an issue with that, that was what the intentions were. And as far as, obviously, there's several pages here that they dealt with. And I can't answer that question, but maybe legal could give you a better explanation of the question you just asked.
Okay. I don't know if that's something that legal can answer, but I'm just curious of how the legislation would be affected if we just replace the word handgun with firearm.
Okay, let me check with the sponsor on one thing.
Okay.
So,
Thank you, Mr. Chairman.
so sponsor, I appreciate doing all this for the second amendment. Would you like to roll this 1 week to get with legal and everybody to amend it the way you want it, and that way we can do it right the first time?
Mr. Chairman, I'm willing to do whatever the committee feels is best, and if that's what you feel is best as chairman of this committee and Chairman Farmer, I'm great with that. I would also like to say, last week we rolled this because safety had some concerns. So we had all week, and then I come this morning and they just bring those to me, and I don't think that whether that was intentional or not, that's not the way I like to do things. We rolled it a week for safety and some of these concerns, and I don't mind rolling it at all if that's what you feel is best. So.
So I think last week we rolled it due to running out of time.
I asked you to roll it before. I'm sorry.
Absolutely. But let's go out of session. I want to hear one thing from legal, and then we'll go back in session and deal with that. But out of session, legal, you're recognized.
Michelle Fogarty, Legal Services. Representative Garrett, the bill allows for it expands an enhanced handgun carry permit to from handguns to firearms. So everywhere that an enhanced handgun carry permit allows someone to carry a handgun was changed to firearm permit. If you just change handgun to firearm everywhere, you're going to cross into constitutional carry, which there are places that permit holders are allowed to carry that constitutional carriers are not. So it's up to the intent of the sponsor whether or not he wants to just limit it to a permit that extends an enhanced handgun carry permit or a concealed carry permit to a firearm permit. That's different from just changing handgun wherever it appears to firearm, because there are differences between where someone can carry a handgun under constitutional carry versus where a permit holder can carry a handgun.
Anything else, Representative Garrett? Okay, we'll go back in session. And Representative Grills, you're recognized.
Thank you, Mr. Chairman. And if it'd be okay, I'd like to roll this for 1 week and
wait
get
just
with
1
you
second.
and Chairman Farmer, if that would be okay, to make sure that we get.
I got something better. We're out of time, so we'll just roll it without it counting against you. How about that? So, rolled 1 week for
Thank you,
House
Mr.
Bill
Chairman.
1898. All right, members, we got any personal orders before we adjourn? Seeing none, I hear a motion to adjourn. We are adjourned.